everybody, I'm Vandana Bala, one of the corporate brokers at Signature Real Estate Group, and today I am doing and co-hosting this class with Chicago Title. So excited to have them as our partners in crime for a lot of and everything related to escrow and title. Couple things that I wanted to make sure we talk about today was the preliminary title report, specifically why it's important, what you're looking for. That's why I called it the good, the bad, and the holy moly of the preliminary title report, because quite honestly, there's so much in there that if you don't pay attention to it, you could end up causing additional time frames on your escrow. And so for that reason, I have invited one of the best escrow officers in town, Mrs. Carrie Cassane, to teach us and talk to us about this particular, about the preliminary title report. And so I'm gonna really quickly also bounce to Valerie and Teresa. Teresa is our sales executive over at Chicago Title. She is one of my favorite. Valerie used to be, just kidding, Valerie, you still are. Valerie Grijalva is also here. She is the VP of sales, or I don't know what her title is anymore, but also at Chicago Title. So Teresa, do you want to say something really quick?
Sure. We're really excited to be here. It's always great to work with all of the agents at Signature and Vandana's team. We're a resource to you, and we're really excited about sharing some of the things that go on within a prelim. And I'm going to let these two take it, and then there's one part at the end where I'll interject about a few things, but these two, you know, as far as real estate goes and title and escrow, these are your ladies, and then marketing, you can all come to me, okay? But I'm gonna get started with the screen share, and then you guys can take it, all right?
Fantastic.
Really quick, I'm gonna just chime in really quick, Teresa. I'm sorry, you don't need to see my face.
I do need to see your face.
No, because the only people that matter is Carrie and Teresa at Chicago Title. I work for them. So, but really quick, Carrie has been in the business nearly like 30 years. I don't even know the number, but it's an obscene number. And she's also the #1 escrow officer in the state of Nevada. She handles over 100 transactions a month consistently and does just obscene numbers. So if you ever have any challenge on any escrow with any title company, she's always there to kind of run scenarios by. If she hasn't seen it, she's probably closed an escrow at some point that has had every challenge imaginable. So highly, highly, highly experienced. And so you guys are with the best right now. And this is her first Zoom. So she's used to doing them in person and feeds off energy. So the more you guys interact with her, the better.
Awesome. Thanks, Val. And you are correct. I've been working with Carrie for several years now, and she is by far one of the best escrow officers. It makes it my job easier that I don't have to worry about a bunch of stuff. So with that, Mrs. Carrie Cassane, you're up, darling. Let's talk prelims.
Let's do it. Okay.
And by the way, I do appreciate you taking time out, because I know 100 transactions a month. Holy crap. Thank you for taking the half hour, 45 minutes to an hour, however long this takes.
Oh, my pleasure. My pleasure. The one thing I want to start with is on a prelim, I've always said that is your whole, it's like your Bible. That is what you want to look at every single day. Well, every single day. Every time that the escrow opens, you want to look at that. That's the first thing you want to take a look at. So if you want to, I'm not sure, Teresa, thank you. Okay, so it starts, you can do stuff preempt the escrow. If you start at a listing point and if you know that the property is in a trust, you want to ask for their trust agreement. Or if they're kind of hesitant of giving you the trust agreement, LLC documents, or corporate documents, you want to at least let them know these items are going to be needed. Because when you get into escrow and we're asking for them, and they're like, well, we don't have them, we don't need them, they do need them. This is our way of seeing, okay, it's in an entity, a trust, LLC, corporation, and these are the corporate documents, the entity documents that they can transact business within that entity. So it is very important.
Can I back up for a second?
Yes.
So one of the things I think I want to remind agents is that when you go for a listing appointment, even prior to, there's a lot of work that you do ahead of time, right? One of the things that you're going to prep is you're going to pull the tax records, and in there it'll indicate if the property is in a trust or an LLC. The next thing you should be doing is contacting one of the sales executives over at a title company so that you can pull some form of property profile, so you have an idea if there's any of this other stuff going on. So when you come into a listing appointment, you're essentially armed with as many tools possible to really run through a proper preliminary or property profile or whatnot, right? I think that needs to be the first thing that we remind agents. And so at the listing appointment, like Carrie was saying, you are definitely checking to see in the, prior to, on the tax records, if it's a trust or an LLC, you got to get this stuff. You got to ask for it ahead of time. So sorry, I didn't mean to interject.
No, and I want you to, because you're going to be on the real estate side. I'm just totally straight escrow. So, and
Awesome.
That's what it is. When you go to a listing appointment, before you do, know your parties, know who you're dealing with, because that way you go in, you have confidence, they know that you know them, and you've done your homework. So it's a win-win. And then when you get to escrow, they're already prepared to provide that information, because a lot of times, like with the trust agreement, some of the parties want to try and use a power of attorney. Well, in a trust, you're not able to use a power of attorney. Very, very seldom I have seen a trust allow for a power of attorney. I think once in my entire career. So that's where, if any sort of discussion points, make notes and bring it to my attention or your escrow officer's attention. That way you can address them before we get into escrow, or at the beginning of escrow instead of at the end.
So I think that's also key, Carrie, is that if you are communicating with your escrow officer, you can help process this faster, right? The escrow can move forward quicker. You've identified if you need additional documents, you've prepared the client. I mean, essentially that's our job, right? Our job is to make sure that we set the expectations for our clients when they're dealing with the escrow officer, who they're going to be contacting, who's going to be calling them, who's going to be sending them documents, what documents are being sent, and then specifically about if there is a power of attorney, how that works. Now, I do want to say really quickly, you will never, as an agent, you will never have a power of attorney, and nor are you allowed to in our company get a power of attorney for a transaction that you are on the listing side or the buy side for. So let's just let me just get that out of the way, because I think we've had an issue on that once or twice in our company. We don't allow that. If you are a licensee, you cannot have a power of attorney and make decisions for your client. There's just no way we're going to allow that. Sorry.
And no, and I'm glad you said power of attorney, because a lot of people, if they say they have a power of attorney, you can never use that as self-serving. And to Vandana's point, if you're getting paid on a transaction, that's self-serving. So that is something that you do not want to be in a position with. And on your seller or buyer side, the same thing. If they're using a power of attorney and they're married and they're saying, oh, well, I can sign a spousal deed over to myself. No, that's not going to happen, because you can never use a power of attorney in a self-serving situation.
Awesome.
Okay.
Okay. And then you said you have here, obtain HOA information.
That's always important, because one thing that happens is we get into escrow and they say, you hurry up and order the HOA information. But sometimes it can take 24, 48, 72 hours to get that prelim. And we do not know that the HOA information until we get that prelim. So if you guys have that up front, that can always help. We can always do it through escrow. So I'm not trying to say, hey, do our job, but at least if you have the information, you can say, and Vandana is very good at that. The management company is this. And so we can automatically take that information, locate the management company, and order the links for you. Now, when we have the regular transactions and we have 45 days, not a problem. We can, have the succession of time go through. But when we have those quick deals, you definitely want to have that information up front.
Awesome. Next slide, Terry.
Understanding
Teresa.
the prelim.
Who's Terry? You don't know. All right. Understanding the prelim, section
Yes.
8. what is this? I get this every single time. I'll see it on there and I'm like, why? What is the purpose of this? Let's talk about that.
The purpose of this, the very first thing is who title says owns it. So now you're going to see a couple different ways. You might be dealing with Mary Jo Smith. However, when you get the prelim, it says Carrie Cassane. And the reason you want to look at who's the vested owner, the very first time is that if that is not the parties you're dealing with, there's a reason. And the issue is that there could have been an uninsured deed. Has anybody ever had like a prelim that says, you know, Carrie Cassane subject to items 10 and 12?
No.
The reason, no, you haven't.
No, maybe. Have I? I don't know. I didn't. I don't look at my prelims. I'm kidding.
Hey, Vandana, you have. I've taken care of it for you. So, so what it is that there's been uninsured deeds because a lot of people say, hey, just deed it over to me and, you know, no title insurance. Let's not do that. But what's happening is that that's considered an uninsured deed. So title is not accepting that. We have to go back to the parties and get the validity statements for those. So was
that happening during the HOAs taking over the properties where they were foreclosing on them and then people were trying to sell them after that? Was that what that was, right?
That's one of those issues. And it's also, you know, a lot of times in that period, people couldn't take title. So they had their sisters or brothers or friends have title, and then they just deeded it over to them when they were in a position to take the title. So there's several reasons, or there's just, hey, they're good friends and I'm going to give you $20,000, I'll buy your property and let's do the transaction. Those are uninsured deeds, so we don't know what agreement or what reasoning they did that, so we have to go in and double check those reasons and contact the parties of who needs to sign a validity statement and make sure there's no outside agreements.
So, okay, so here you have, so we're confirming that the people who were sitting in front of at the listing appointment are the people who are actually authorized and able to sign off on all the other documents to closing, right? I find that a lot of agents will get signatures from one party, get into escrow, find out that the prelim has actually got an extra person added to it. So there's somebody else on title. And now we have to get signatures, and they were advertising a property and marketing it for sale without everybody on there, which is why I think it's important that they do some initial research to begin with. Yes. The legal description, and you have on here, does the legal description match the one on contract? Now, the only thing we actually see on a contract is the APN number, right? We don't have the actual legal description, which is usually a paragraph long of, you know, it's in this corner underneath a bucket close to the, you know, freeway or whatever it is.
Yes.
But it's extremely detailed. How do we know that that's actually correct and that matches?
Well, and basically the legal title goes on the APN number. So what happens is you just want to make sure that APN number is the property that you're dealing with. Sometimes when a contract comes in, it could be a digit off or not. Title pulls that APN number, and it could be another property. And that's actually happened in our escrows. We've actually sent a prelim out, and it's like, wait a minute, this doesn't match because the APN was wrong on the contract. So that's kind of what they're trying to refer to.
Oh, got it. And so the way that the contract usually comes out, and a lot of people nowadays, especially when you're getting outbid on properties and you're working with a buyer who's put in an offer, then puts in another offer, I think agents forget, they change the address, but they forget to change the APN number. And that's usually what happens. So when that happens, Carrie, do you on your end from the escrow side, I know we're talking prelims, but I really want to talk about it, but do you on your end ask for an update, an addendum to that to show that the APN number is different?
We do. We'll ask for an addendum to correct the APN, or we'll ask for an addendum to correct the address. Whatever it pertains to, we'll ask for an addendum.
Awesome. All right, cool.
Yes.
What's
and then are the buyer's names spelled correctly? When you get into escrow, you'll say, okay, you call them Amy, but their real name is Amanda, legally. So right now, you want to make sure that when you do their contract, you do it in the names that they're legally known as. Because
Okay.
what happens with that on a cash deal, not really a problem. When you're dealing with a loan and we get down to closing and they put it in Amy, and because Amy could have credit in their name, so it's not a problem with the lender. But when we go to closing and that legal description is in, legal description, their
Name,
ID,
legal name.
their ID legal name is in something different, the notaries have a problem with it.
So ultimately you're looking for what's on their ID is what's
Yes,
going to matter.
yes.
Okay,
Yes.
perfect. Now there was a question about HOA liens, but it looks like we'll be dealing with that a little bit later. So we haven't forgotten about you, Tricia. We will get back to it. Okay. All right.
Okay.
Is
And
the purchase price correct?
Yes, purchase price. Just that make sure that when we send out the documents, the purchase price is correct. Because a lot of times we may not get an addendum or a counter, or we might have misread them. Not my unit, but you know, it does happen. But there is. So you want to make sure that the information we have is what correctly reflects on the documents you have. Because there is times we don't get the counters and it's missed. So we don't want to get through the transaction and have a problem with the sales price.
Awesome. All right. So here's a preliminary title report. Some people call it a commitment. Some people call it other things. I mean, for many years it was a preliminary title report. Now it just shows preliminary report. It's changed names so many times. We use it interchangeably, but ultimately the prelim, right?
Yes. Yes.
Okay. So what's all this stuff in highlights over here?
Well, this information is our title officer. You want to make sure it's your buyers. Those are the buyers that are correctly reflected. The sales price, that's where you can look at the sales price. The lender and the loan amount you don't know. That's going to change throughout the transaction. But the key point, is it your buyer's name and is it the correct sales price?
Okay, so super easy. First page, top right-hand side. You're just verifying information. Sounds
Correct.
good. Easy
Yep.
enough. I like it already. Next.
No, back up. Sorry, real quick. Back up.
Oh,
Sorry.
just kidding. But wait,
Okay,
there's more.
just kidding. They didn't highlight the property address. This is where you can look at it. So it's kind of like everything right there. Sales price, buyer, and sales and property address. So that would show.
Now the effective date, that's the effective date of, like, let's say for instance, if we went into escrow today, that's the effective date that the preliminary title report shows up to us.
Well, no, the effective date is where our title plan is, because you need to know with the county recorder and title plan, they're sometimes 2 weeks behind. So we do it the effective date of the title plan. And that's why we do a final date down at closing to make sure nothing's transpired between.
Got it. Okay.
Because it could be that time frame.
Cool. All right. Does anybody have questions on that page? Now's the time to ask. Okay, if you do, you can put it in the chat as we go along. We will check them, or you can unmute yourself and ask the question. All right, let's talk vesting. Schedule A.
Right. We kind of address
Went over
this. Owner of record, is it in a trust, LLC, or corporate vested? Are the members, who's the members, the documents are needed for title married. We're kind of address that to where we need those LLC documents, entity documents, prepare your clients, hey, they're going to need this information. The key part with married, there's a lot of out-of-state parties that can, in their state, buy and sell property all day long without their spouse. Okay. Here in Nevada, we are a community property state. So if there's somewhere that allows this and they bought property here, we do need to address their marital status. So if they're married, they need to sign a spousal deed.
Okay.
On cool. When they're selling, yes.
Okay. I think we've talked a lot about this. One of the things I do want to mention though on married, even if they're divorced, if they don't have the divorce decree, I think you guys still need them to sign off on the property, right? If it's only under one person's name. I mean, that's the part that gets confusing for me all the time.
Okay. And it is confusing. A lot of people, they will have gotten the property through a transaction, through a divorce, but what happens, they'll do a deed on their own. So we can get around that without getting another deed if they provide us with the divorce decree and we can see, hey, he agreed to sign this, or he or she signed this deed in connection with the terms of the divorce decree, and then we can move on. If it's just like a deed between them, we're not going to accept that unless A, it's been done with an attorney and approved notary, or we can see that divorce decree to make sure there's nothing pertaining to the property that would affect us insuring it.
Awesome. Okay, good.
So if there is a divorce, you do want to say, hey, again, as agents, you want to take caution on asking your clients all this information, but just prep them. Hey, this is something that they are going to need at closing. So it's not a shock when we're into escrow.
Got it.
Okay.
This is what the vesting looks like on a prelim.
Yeah, this is an example of a trust. You're going to see the trustee's name under their living trust. So these are the trusts that we need. A lot of times throughout the years, they might change their trust, amend it. We need to make sure we have the original trust, and then we have the amendments for that they've done prior after that. So we want to make sure we have the trust agreement. We're dealing with the same trust that's on title and the trustees of the trust. Now, one thing about the trust is sometimes they're successor trustees. That's why the trust certification sometimes will work, but if there's a deceased trustee, we need the full copy of the trust, because we need to make sure we're following the terms of the trust for any successor trustees.
Now, us on the real estate side, and I'm going to just back up for a minute, because us on the real estate side, we don't need a copy of the full trust. We never do. In fact, you should never be asking your client for that. All you need is a certificate to show that they are in fact the ones in charge of this trust and that they can sign on behalf of the trust, because that's the only way that you can list the property. So I just wanted to jump that in. Okay.
No, and that's fine. And a lot of times, if it's the Vandana trust and we're dealing with Vandana, then that's not a problem. It's different if it's a Carrie Kissing trust and you're the successor trustee. That's when escrow will need, title will need the full copy of the trust.
Awesome. Okay.
Then you have an unmarried woman, an unmarried man, anything like that. If they're still unmarried, no problem. We're just smooth sailing. If they've gotten married or gotten married and divorced, which we've had that in situations that they've owned the property, they got married, they divorced, and now they're married to somebody else. We have to go back to that chain, because anytime they get married, there's that community interest involved. Now, what gets tricky is they say, you know, per state law, if I owned it before marriage, that's not what we're concerned with. In a court of law, they may definitely get awarded the property because of that. What we're ensuring there's no other interest of any other parties to this property. So when they go in, get married, take it out, get married again, all those spouses need to be addressed.
Okay.
Okay. So that's where it gets a little tricky. So if you know, and again, it's so hard as agents to want to have to ask their whole, you know, history. But if you know that it was unmarried when you pull the property profile and you know that she's married now, that's a discussion to have.
But we, on the agent side, we don't need signatures from the current husband or the ex-husband or whatever, unless they're on title. So I just want to point that out. On our listing paperwork, we won't need that information.
Yeah, exactly. Just you would need it in escrow would need to address it.
Right.
But again, it's always better
setting that expectation.
Call your escrow officer, see what needs to be done. So that way, you know, the communication has started and it's not a last minute, okay, we're ready to sign and bring your spouse. And they're like, what? Yeah, my spouse is in China or Singapore. And that's an issue.
You make a really good point, Carrie, because it's not our job to rummage through those files, right? And to try to figure this out. That's your job. And so you should be calling the escrow officer to see and allow them to guide you on what you need, right? We always talk about in real estate, it's important to be the source of the source. And since you're not the expert on this, send them to somebody who is, or get the information or tell them, I will find out for you. I'm going to call my escrow officer and see what they need.
Yes.
Okay. Sorry, go ahead.
No, communication is key. That's it. Okay, and then when you're looking at a prelim, you definitely want to look for liens and judgments. Those items fall under deeds of trust, child support, IRS, like the delinquent taxes, mechanics liens. All these items have an effect on the outcome of the transaction, because if you weren't aware there was a deed of trust, about the deeds of trust, there's a lot that I'm finding, silent deeds of trust. And silent deeds of trust are, well, wait a minute, I have not paid on this for 7 years or 10 years and nobody said anything. Well, what they do, they just hang around. And when they close, lo and behold, there they are, and we have to address them.
So what's a good example of a silent deed of trust?
Silent deed of trust is, before the market crash, they had first and seconds. So the first, they might have modified. The second had no way of knowing what needed to be done. I mean, they knew they couldn't do anything because the property was underwater. There was a first or second position. So they just stay silent. They back off, no notices, nothing, just to pop up in times like this when it is flourishing, to where, okay, now there's equities in the property. What do we,
got it.
We have to do this. Now the issue with those and the other thing is that a lot of times I get people, they did bankruptcy and they're no longer obligated. Well, they're no longer obligated on that level, but the property is obligated because the deed of trust is securing the property. The property is securing that deed of trust. So that's where it comes up at closing. So again, and Teresa's going to answer your questions and address the appropriate profiles. That is important because it'll show you all the deeds of trust on the property so that because a lot of times I currently have one now that, no, we don't have a second. The prelim comes up, there's a second, and it's, oh, it was silent. I haven't paid for it on 10 years. So we're dealing with that.
Okay.
But looking at the prelim, you'll see it'll always show the taxes. So you can see right here, you'll see if there's any delinquencies.
So that's, hold on, which one is that? What number is that? So that we
Item
can,
one.
because item number
one.
one. Okay,
Yes.
so that's your taxes. And that's usually the first one that shows up?
That is.
Okay.
That'll show the taxes. That'll show current taxes, delinquent taxes. If your client is behind in taxes, or you have the buyer and the seller's behind in taxes, it'll show them.
Okay.
Okay, then it'll always pop up if there's a special assessment.
Those are the SIDS and lids, correct?
SIDS and lids, yes.
Perfect. Okay. And it'll show if it's paid for this. Oh, it doesn't show. It just shows a payoff amount.
Well, it'll show the next installment. It'll show that. Figures are good too. This is an old prelim, but it's still the same. Still, it'll show what the original amount is, what the payoff amount is, and what the next installment is.
Okay.
And then if it's a large balance, you'll see that it's delinquent.
Got it.
Okay. And then like 4 through 8, these are all the items that are going to, like if there's any supplemental tax bills, usually this doesn't come up unless there's like a new home that they purchased and they're going to sell, because what happens is that when it was a new home, the tax assessor might have based it on vacant land. So that amount was $200. So now when they went to, they reassessed it, there's another supplemental tax bill and it could be a couple $1,000s.
Okay.
Okay, and then just that, it's always subject to the utilities, the municipal, the water, sewer, trash. So that's a common one that's always going to show. Water rights, whether or not disclosed, that's a common one. Those items you're not going to be able to do anything about. It's always there. Mineral rights, same thing. There's a lot of the properties, probably 99% of the properties are recorded with mineral rights from the state, the government. They own any mineral rights in the property.
Okay.
And my eyes, development agreements, that the developers would record development agreements in order to, prepare the property for development. So those items are all going to show, not an issue. Easements is where you want to, I'm jumping over to 9. Okay. Easements, this is where you're going to look. There's always going to easements for the utilities, water, power, sewer. Those are always what's going to be of record. and we'll show later on in the slide, the one easement that you want to look for is that conservation easement. Those will pop up and we'll show you what they look like, because those are the ones that you want to, if your buyer sees that it's desert landscaping in the backyard, but their whole thing for purchase this property was to build a pool, you're going to want to know if there's a conservation easement.
Okay.
CC&Rs are going to be a part of it.
Now, here's the other thing is I always tell people, so I've been very lucky with you in the sense where anytime you guys send me a prelim and there's an easement, a water easement on there, you send out like a notice that says, hey, a heads up, there is a water easement. And so I've been lucky in that sense, right? We haven't actually had an issue.
Right.
But I think agents just, if you don't mind, Teresa, can you zoom in a little bit so we can see that? Because I really want people to see what that looks like.
I think it's the next page. It's down on the next, yes. Sorry,
Okay.
that's why, no, it's not those. I kind of jumped because I was going over easements. I'm jumping ahead. I'm escrow. I go straight to the finish line.
Yeah. So there was a question from Trisha about paying off that easement, and the answer is yes, you can have it paid off. Now, can it be done through escrow? I'm assuming not, unless
No.
it's a contingency of some sort that the seller does it prior to closing, in which case you can have the seller pay off that easement and make it a part of the final closing, essentially. And I'm just speaking from the agent's perspective. But the escrow side, you guys can't pay that off if somebody does want a pool, but it is doable, Trisha.
Correct. Yes.
You would just have to call and find out with the water authority what the cost is, how much to pay off the bond and the penalties and blah, blah, blah.
Yes, and
Okay.
they will. There's a process. There's documents to be signed, recorded, and amounts to be paid.
Cool.
Okay. Deed of trust, you're going to see these. These are the ones that you want to look at, because if your seller said, I only have one deed of trust, and then there's this one. Next slide, Teresa, sorry. The next, and I just want to make sure there wasn't any. So there's this a deed of trust. You've got one, we're fine. You're going to see deeds, prelims that have 1, 2, and 3 deeds of trust. The one thing you want to look at is some deeds of trust are already paid, but they're still going to show on title, because title wants us to verify that they have been paid. Because if they haven't been paid and reconveyed through an insured transaction, then they want us to verify personally that these items are not a problem. So don't be alarmed if you do see a deed of trust and it says a satisfaction, the effect of a satisfaction. That means it has been paid. Escrow just needs to verbally confirm it before title will remove it.
So I just want to back up for a second, because this is a deed of trust that's specific to the property and the owners now. It's not like you're pulling the property history and pulling deeds of trust from the past, correct?
Right. No,
Okay.
right. This example is the party's deed of trust.
Okay, the ones who are selling.
Exactly. You will see prelims that come out that is a previous owner, that maybe a deed of trust has never been reconveyed. We have to deal with those as well. So we have to reach out to the title company, or if there wasn't a title company, we have to reach out to the lenders to obtain the information and the releases in order to clear the title.
So it'll show up here, and essentially when you pull the preliminary title report, you're supposed to send it to your client and be able to explain it to them. I usually say call Carrie, but but you are supposed to be able to say, hey, it looks like you've got 3 deeds of trust on here. Just make sure and verify that those are in fact paid off, or because you'll have to mention those when you do your statement of information, right? Again, setting the expectation for the client.
Exactly.
Okay.
So, and that's always, again, take a look at it when it comes out, review it real quick, call your escrow officer. Hey, is there anything I need to worry about? We'll go over it and tell you, these are the points of concerns, or no, we have this, we need to verify it, we'll be good. So that way, and then if you want the escrow officer to talk directly to your customer, it's always good. I mean, in this situation is that, because then we can talk apples to apples and answer their questions. You can always be involved, 3-way call, conversation, whatever you are comfortable with.
All right.
My eyes aren't what they used to be.
So
Okay.
Statement of information on
Yes.
this one.
Statement of information. This is, if you see this, this is behind the scenes that escrow, you see this one item. when we get the SI, or there might be 20 liens that we're trying to clear. And again, the most popular names, the Jones, Smith, Garcia, they're popular names. So we might have, you guys see this, we might have 20, 30 liens that we need to go through to clear. So wow. That's why when you see the statement of information, and this is where it's really important in escrow and agents are on the same page, is escrow asks for the information up front for your clients. We send out opening packages. So critical that those sellers and buyers complete them and return them right away, because we can start working on these. A lot of times they won't have them return them till later in the transaction. And then we have to do a lot of footwork to get these items cleared. So it is so important to get that up front, those packages.
So sometimes if there is child support lien put on, it could be for somebody else with the same name that has nothing to do with this particular person, and they've already collected their child support based off of a lien, and they stuck it on here as a possibility, right? And there's also fraud and blah, blah, blah. But that's your job, is to make sure that all of this shit's cleared. Sorry, I said
right.
shit.
And let's talk about the difference with liens and judgments. They are different, very different. Liens are recorded against the property, and it has to do with that property. So if you see a lien, more times it is our property because they've recorded against our proper legal description. Judgments, they are an item that hangs out there. So when it's out there and this Carrie Cassane takes property, if there's a Carrie Cassane judgment, it'll attach to property they own or the property they're going to purchase. So judgments are a little different animals. So what happens is that they might not even know about it, but because their name is James Smith, every James Smith, Jay Smith, Ronald James Smith is going to come up under it, because we search every single name that could possibly have an effect on our property or our parties.
Well,
so
sorry, go ahead.
No, I was just going to say that's the difference between a lien and a judgment. So just so that you know that when you're conveying this to your client, just say, hey, this is something that may or may not be yours. Or do you have child support? I mean, I've had to where a wife said, are you telling me he's got child support? And I don't know. No, that's not what it is. It's because it could be anybody out there. We have to make sure it's not our party and move on.
So we just recently had an issue where there was in fact a lien, and it wasn't with you, Carrie, it was another agent in the office, and it wasn't with me, but there was a lien on the property, and nobody looked at the preliminary title report. Nobody paid attention or reviewed it. The sellers didn't, the buyers didn't, the agent didn't, obviously escrow did, but nobody mentioned it. And then you get to the closing and you're looking at the settlement statement, and now there's a huge deduction on the settlement statement from the seller's side. And they're like, wait a second, I was expecting to get, your net proceeds showed blah, blah, blah. And now I'm getting $100,000 less. What happened? And that's when it was mentioned from, and it obviously wasn't your team, because if there's a discrepancy or a lien like that, you guys are pretty good about informing the agents to be aware of it. But it ended up causing a delay because now the seller didn't have the money to close on the house that they put an offer on. Right. They had to figure out, they had to clean up that lien. And I know it's not child support or whatever, it was mechanics lien. So that might be the next slide, not to push you forward. But the mechanics lien, I think, is something that people just don't even pay attention to, because contractors put liens on properties when they start the work and then never remove it when they finish the work. And you get to closing and now you have to go clean that up, and it's going to delay your closing by 4 or 5 days, which is why it's so important to go through these things.
Right. And it is. And the thing is with the judgments, what I try and do is when we get a prelim with a judgment on it, we send it out to the agents and say, hey, check with your clients to see if this is them or not, because there's 2 ways to handle it. One, if it isn't theirs, we'll do our work, contact the attorneys and get them cleared. If it is theirs, we as escrow do not want to contract, in my opinion, I don't like to contact those attorneys until I give the parties the right to, because they can negotiate these items. So a $10,000 amount, they could negotiate, you know, for pennies on a dollar and pay 3,000. But
Right.
the minute escrow contacts them, it's all on. They know there's an escrow and they know they've got the parties
Mm-hmm.
on
They've
the
got
line.
them they've got them in a
Yes.
hook. They don't have, they've,
Right.
I want to say a bad word, but I won't. So we have, I think ultimately the message needs to be, if agents don't know how to read this, they need to call you, because
Exactly.
finding those liens or judgments or anything that attaches to property ahead of time is going to be the most, I think, the best way to close your transactions on time. Right? So you're not delaying that process. When you're just sitting here waiting for lender to get their crap together, you should also be getting your crap together and checking on these liens. Ooh,
Right.
easements. I love these things. Not
let's
so
go
much.
back. One little point to your comments is that we definitely need to talk, because a lot of agents will say, we'll worry about that later. But when we need LLC documents, we need statement of informations, we need all that, that could come down to the line that it's going to delay your closing if we don't have that information up front.
Right.
So it's best to get everything up front. Okay, here's the beauty of the conservation easement. This is what it's the actual easement that you would look at. With our prelims, which are wonderful, if you guys see our prelims, there's a linked report. That report, if you click on that blue link, it'll pull up the document that it's referring to. So there's no guessing, there's no calling us, what's this, all that. You look at that prelim, you double click on that blue link, and this document's gonna come up. So this will show you conservation easement, and that'll be an item on the prelim.
So this is that water authority easement where they could no longer build a pool, or that they'd have to pay it off. Or what that document that was signed by the client when they took the credit for converting into a desert landscaping.
Exactly. And you guys as agents, what you can do is visual is key. So if you go to a property and you see a lot of desert landscaping and it wasn't that way in the beginning, they, you know, not that you would know, but there is a lush.
If you look at old pictures on the MLS, maybe.
Yes, and you look at that and you see it, there's a key. You know what? There's probably some sort of conservation easement. Or if there used to be grass and now there's turf, there's probably a conservation easement without even having to look at a prelim.
And lucky for us, we've actually got it in the seller's real property disclosure. It shows it in there. It has a question to ask. Sometimes the sellers don't even know, to be honest with you, but.
They don't, because they know, hey, I did this, but they don't realize it's a conservation easement. They don't know that it affects their reselling the property. And then you'll see the map on there. See how it shows in the area? This is where the area that's the conservation easement, and there's no building or no pools or anything in that area. So that's what you want to look at.
Assuming that that's just that backyard and the rest of the square is the house, right? I'm making that assumption. But let's say that wasn't, the house was only a small corner on the bottom right or something, then they could utilize all that white space for a pool if they really wanted to.
Well, and more than likely though, the house is around there. So more than likely they've transferred the property that they could do with the conservation easement. But if you have a huge backyard, absolutely. There might be other areas that they can put a pool in.
So quick question, Carrie, would a new home builder ever do or get a water easement just to, you know, like on a property that's already getting ready to close? It's quick inventory type of thing. Trisha just asked the question. I'm going to say the answer is no, because they usually give you nothing in the backyard. It's very rare. And if they do something, desert landscaping is cheaper than having to go through the whole easement nonsense, but because they're not converting anything. But have you ever seen it on a new home?
You know, I don't do new homes. I haven't done new homes for years, so I'm not sure, but it's definitely a question to ask the builder. And the reason why, because a lot of the builders are now doing desert landscaping. So maybe they got their development approved based on conservation easements. So it's definitely a great question to ask if you are dealing with the new home.
And you get prelims on new homes as well, so look at those. Okay,
absolutely.
Cool. Next.
Okay, and then you'll see the circle, the 15 easement. That's way it will look on your prelim. It'll say easement and then granted to Southern Nevada Water Authority. That's the key. A lot of people just see easements and go past it. That's when you want to look for if it's an issue with your transaction.
Now, there was another question on homesteading, just to answer. It's for any legal or litigation or judgments against you. That's what homesteading would protect you for. Is there anything else you want to add to that, Carrie?
Well, in my understanding, it's just if it's your primary residence.
Correct.
So that's something you want to, make sure when you're doing it. But my understanding, it's your primary residence. There's a cap that the state of Nevada allows to where you're right. Any involuntary liens or lawsuits and that, it would protect you. But that's kind of out of my expertise.
Okay. Cool. What's this?
These are the title discounts that we provide. Oh,
got it. Title discount. So if you are working, if you have the same client that's buying property or selling property, you offer discounts. I'm assuming that was Terry, Miss Terry, Teresa's little tidbit, right?
No, mine is next, but go ahead.
Okay.
And like the short-term rate, which Chicago Title does automatically without you guys even having to ask for it. We do that automatically. Some title companies don't. You have to ask for it. But short-term rate, we automatically put it on, and we give your sellers credit for that. And that's just stating what it is. If it's been insured in the last 5 years, they're applicable to that. It would be.
And it says does not apply to short sales.
Right.
In fact, there's an extra fee for short sales.
Yeah, there is. Hey, and short sales are coming back. I've had a few lately.
Don't say that.
I know, but they're here. There's the investor discount if they've held title or have transferred 3 or more investment properties within the last 12 months. We provide them with 30% discount. We have a military discount and senior discount, which both apply to the escrow fee. The senior discount must be their primary residence. So we do have discounts there.
Awesome.
And then one thing that's not on here, Carrie, real quick, will you talk about a binder policy for flippers if you're working with a client that does flips?
Yeah, there's a binder fee that if they're going to resell the property within 2 years, we do an interim binder. And then when they go to sell it to, they rehab it and sell it to the ultimate buyer, there's a fee that we charge up front. They get a discount, a bigger discount than the investor discount on title insurance. So instead of saving a few $100s, they can save several $100s, sometimes $1,000, depending upon the price point of the property.
Nice. Okay.
Great. Okay, now this is my slide. So there's quite a few times where people will call and say, hey, pull a prelim for me. I'm taking this listing. And we don't just automatically pull a prelim just because you're going on a listing appointment or you're going to get a listing. A prelim actually costs us money. It takes a lot of time and research. You've seen what goes into a prelim, but the tools that we do have for you to get the information on the property, we've got a property profile, which you can access on your phone through our Chicago Title Now app. And if you don't have that app, reach out to me and I'm happy to get you signed up. But you can put in an owner name, you can put in an address, you can take a picture of the property, and it will pull up the whole property profile for you. It'll have the vesting, the legal description, it will have comps, demographics, schools. So it has all of that information in the property profile. What it doesn't have are liens, judgments, easements. Those will not be in the property profile, but it will give you quick information. If you want a more detailed report when you're taking a listing, reach out to us it's called a property summary report or a PSR. And I'm going to show you the next page, but that will give you kind of a 10,000 foot view of what that property looks like, what mortgages are on there, or if there's any seconds on the property, home equity line of credit, if there are any liens on the property, and any other, like it'll show an HOA lien, it'll show the first deed of trust, it'll show any other mortgages that are on the property, and then it'll also show if there's any Republic service liens, and Let's see, any water liens. So this one shows a water lien. This one shows a notice of default and foreclosure. So that's a really quick report that we can get you within a 24-hour period that will show any kind of liens and judgments on the property. It will not show easements. Okay, an easement is within the preliminary title report that you get once you enter into escrow with us. So anyway, there's a couple different ways where we can get you information on the property, but if you do not have the Chicago Title Now app, make sure that you reach out to me and we'll make sure that you get it, okay?
And then you're showing here that it's got solar as well as, or water softener liens. It's kind of cool.
Mm-hmm.
We didn't really talk about that. Okay, sorry, go ahead.
That's okay. Let's see. Okay, so I did put a link in the chat box and it has all of these different documents for you. I put it in magazine format, so you don't have a bunch of PDF files, but we've got a description of the Alta title policy. We've got a chart of the life of an escrow. We've got a flow chart of what the escrow looks like as it's going through. We have the 8 different ways to hold title. For when you're working with your buyer, you can present those to them, how they would like to hold title on their new property.
I'm going to stop you really quickly. Just remember that you are not in charge of explaining that to them. You can hand them that piece of paper and allow them to decide how they want to take title, but it is not your job, nor should you be advising them on how to take title. That is something that's completely their decision. Again, that's one of those items that when someone says, well, I don't know what to put here, I'm like, well, you should call Carrie. Here's her phone number, 702-836. And so I say, that's out of my field of expertise. And it's really a decision that you need to make. But if you want to understand what they are, please contact the escrow officer.
Yes.
Sorry, continue.
No problem. And the other 2 documents are red flags of the preliminary title report. So some of the things that we just went over today, and then also a guide to title insurance. So that is all in the link that I put in the chat. And I also gave it to Vandana and she can email that out as well. And then now it's time for Q&A. So do you want people to unmute themselves?
Yeah.
Or,
yeah.
Okay.
Yeah, I know that there was something, Trisha had asked a question in here. She said, for later, do you ever have issues with the HIP 0% second grant not falling off after 3 years when it is supposed to?
Well, there is some that they don't automatically just remove. It does go by the wayside. So what happens, we do have to contact the parties and get the release, get a zero demand release and record it with the transaction. So yes, it does happen.
Okay. And then did that answer your question, Trisha?
Yes, yes.
And then are we having a lot of issues with the HOA liens? The banks are going back and suing them and there is still litigation.
There is. We're finding that, and that'll show up on the prelim to where, and that is an issue. A lot of the times, if it's been an HOA foreclosure, we need to do some serious research, obtain information, because an HOA foreclosure is not your normal trustee foreclosure. Mm-hmm. So it's not a given that, oh, we're going to insure this. We will insure, but on a case-to-case basis, if we have all the proper information, usually deeds from the previous owners, and sometimes those deeds from previous owners come with a dollar amount. So there's a lot of various factors involved with those type of transactions.
So also remember, you guys, you can actually, if you're having issues with people on the other side of the transaction and, they're insisting that they use a specific escrow officer, fine, whatever, you can always direct title. And so if you're more comfortable working with a title rep from here and you're being forced to work with someone else on escrow, you are allowed to put that right into the contract, because that is a buyer's decision. Okay. What other questions? Did you have any other questions, Trisha, Deborah, Mika, Straya, Jansen, Roger?
No, just that HOA, because I've been seeing it a lot. Mostly not on the particular transactions that my clients were on, not on their property, but properties within that community. So they've been showing up on the HOA resale package. And I mean, it's not affecting the property they're buying, but I wonder if that happened, because I heard some horror stories once. But if they have the insurance and you guys do insure them, that will protect them if the bank wins anything.
Well,
correct?
no, if there's current litigation going on, I don't think the title would insure it because that's up in the air. There's a court case that's going to be decided. So we're not going to go and insure it. The only ones that I've ever seen us insure is if there was no litigation, everything was done from A to Z, and we got the proper deeds from the previous owners, then we may insure it. And we have insured it on those cases. But if there's current litigation going on, I don't think that title would step into that.
Okay.
That was a very well, maybe, and we can, and we might, and we, no definitive in there, Carrie.
I'm sorry, my apologies.
You're good.
I didn't realize the litigation, so my apologies on that. But
So,
anytime there's litigation, it's up in the air.
So how quickly does it take you guys to get, I know you said it takes about 2 days once you've ordered it. How quickly can you get title insurance policies or the preliminary title reports out? I know the contract allows you guys 10 days, and then the buyers have 5 days to review it or cancel based off of anything in there, right? But also it would, and what have you ever seen, so answer that question. And my second question to you is, have you ever seen a buyer cancel based off of the preliminary, and why would they do that?
There's no definitive answer as far as a prelim time. It just depends on the search. If it's a quick and easy search, we can have it within 24, 48 hours. If it's cumbersome and there's previous owners, uninsured deeds, items of record that they have to do some more research, then it could take, 4 to 5 days. But that's not the norm, but it just depends on the title search.
So 10 days is more than sufficient for you guys to get that out, right?
Yeah, it should be, yes, absolutely.
Okay.
And if you agents, if it hasn't gotten to you by the 4th or 5th day, just say, hey, wait a minute, where's this at? Because there might be issues that are going behind the scenes that we don't know about it until that prelim is issued.
Okay, and then also on the buy side, because it allows the contract for a buyer to cancel based off of the preliminary title report within 5 days. So I'm just wondering, besides the water easement issue, that there is one, and it could cause them additional expense to, remove that easement, pay off the bond. What other issues have you seen where the buyer could say, I'm not moving forward with this because of this is on the preliminary report?
Usually there's anything that can set them, trigger what they don't want with the property. If they see a lot of liens or judgments, that can freak some buyers out, and they say, I don't want anything to do with it, even though escrow's there to obtain the documents, make sure everything's clear. And after we have that conversation with them and address, okay, this one isn't an issue, we have a demand. This one is an issue, we're working on it. They might not. So I have had them cancel because the time frame, hey, it's going to take a month to get this cleared. We need in this property by 3 weeks. We're not really in love with it. We're going to go move on. Or they get freaked out about all these liens and judgments because some people, it's all about personalities and what drives them of what they want and what they are looking at.
Okay, cool. Yes, Tricia.
Kind of back on that HOA lien. So this kind of confused me when I was looking at a prelim and it said, in the beginning paragraph, they're prepared to offer the title insurance, because you kind of put that at the top. And then I saw HOA liens later listed from that litigation, but I didn't know off the bat, was it against my particular property that my buyer was interested in, or is it you put in if there's any liens for the HOA in general that might have to do with another property within the HOA?
Well, I've seen it both ways. Usually we're just dealing with our property. So usually it's just their HOA liens or prior owner's liens if they, took title through an uninsured deed. But I have seen it where they have actually, there's been a lawsuit and somebody has liens every single property. Yes. So we've seen it. Now we have to get the releases. And once I had that actually about 3 or 4 months ago, we had to work with the attorneys to get our particular unit released from that. So there is ways to go around it, but it would have to be, we would have to get a release for it.
Yeah, it was a single family, and it's, you know, the beginning is, hey, we're prepared to issue title insurance, everything. And then when I was reading further along, I saw the lien, and of course I was going to call, but something else happened with the inspection report, and 2 people digging up their front yards right across the street and telling them that the whole community has a main water leak problem.
Oh, geez.
But so they canceled anyway. You know, this happened so fast because we got the inspection the second day. And then I got the prelim and was reading that, but they were canceling anyway. But I was just curious if, because they said in the beginning, hey, we're going to prepared to issue title insurance. And then further down, I saw the lien, and I wasn't clear if that was just one other property within that community, because it was a single family, or if it was my property.
Okay, but I probably wouldn't be able to talk intelligently on that unless I actually saw what you're looking at. So I would have to see that, so I could discuss it further. So maybe you can email it to me and we can delve into it a little further, and I can tell you what it is. Because difference between a lien, or if there's an ongoing court action that was filed against the whole community. So there's different ones out there.
Yeah.
So, sorry, are you done?
Yeah,
I don't want to make sure that you're okay. Good. I have a couple of questions really quickly on prelims. Now I know that you usually get them, you said, within the first 4 or 5 days, right?
Yes.
Towards the end, are you rechecking those to see if there's any liens that have been filed? Let's say you have a 30-day or a year-long contract that's a owner will carry, or or even like a property that or lease option or whatever, and so it's a year long, right? Are you looking to see if there's any liens on the property before you close, whether it's within 30 days, 15 days, 3 years, whatever of that escrow period?
What we do is when we open it, we pull a preliminary title report and we review it. And I can only answer for my particular unit. Then before, like about 3 weeks, 2 weeks before closing, we will request an update and look at it again. Then at closing, right before we record, title does a final date down to double check that something doesn't pop up.
Ah, good to know, because that's a good thing for the buyers, right? To know that they're actually getting clear title. I didn't realize you guys did that at the end. I actually had an agent in the office that had a buyer and a seller who were divorcing, and the husband didn't want to sell, but the wife did, and so the husband like filed a lien on the property on the last day, and they couldn't close anymore. I mean, docs were signed, everything was ready to go. They pulled the preliminary, so that's why I was asking that question. So that was good. And then what about unpermitted add-ons? How does that work with title insurance? Like that to me just fascinates the crap out of me, right? Do you guys insure that if somebody unpermits something and then you want to have it permitted? How does that work? And I don't know if
no, we don't insure those. The one area that we do insure is if it's their primary residence and we issue an ALTA extended owner's policy. So if it's their primary residence and that policy is issued, they're covered. They're covered for that. But if it's an investor, if it's a regular, not going to be your primary residence, you are not insured with those items.
Okay, so I'm going to back up for a second. I'm the buyer of a property and the seller is selling me a home. They built their own balcony and they didn't get it permitted because, they can do that shit on their own. I said shit again. And then the buyer comes in and so the buyer closes on the property and they now want to permit that balcony. Can they go back to you guys and say, hey, you didn't?
No.
Can you pay for that? It's on their own, right?
Right.
Okay.
That's why it's better for them if they need to do their research to make sure everything is permitted. Yeah. But again, if it's their primary residence and that extended policy, then yes, they would be covered, but not just a regular entity taking property or standard policy being issued.
Awesome.
Yeah.
I don't know about you guys, but I learned a ton on this deep dive.
This is great, and I've been wanting this, and you get just another little tidbit every time.
Right.
And I'm one who always does call the title people, just even to just kind of say, I've looked at this, we both looked at it, we discussed it, it looks like everything. Is there something I'm missing? Or
Yeah.
But I learned some great stuff today. Thank you.
Awesome. Well, Carrie, I
Sure.
appreciate you. Teresa, I appreciate you. Valerie, I appreciate you. Guys are wonderful. I love being, partnering with you guys on these types of things and for escrow and title needs. So thank you so much for being here today. And if nobody has any questions, I am going to say goodbye.
All right.
Good
Thanks,
afternoon.
everyone.
Thank you.
Bye.
Thank you.
Thanks.
Bye.
Bye-bye.